Well, good afternoon, everybody. I'm sure we don't quite have a quorum yet, but I think we may as well start. Mainly, I'm being a little bit selfish here because I'm presenting a paper next door in the next session, so I'd like to make sure this one finishes reasonably well on time so I'm not late. We have the luxury of time in this session. We've only got 2 speakers. So our first speaker, Ngozi Stewart, she'll speak for approximately 20 minutes, and our second speaker, Nicola Ween, will speak for about 25 minutes, and then we'll have questions at the end of that. And Ngozi is from the University of Leicester in the United Kingdom, and she's going to be presenting a paper today on achieving sustainable development through anthropocentric laws. Is this a feigned commitment to posterity? Thank you. And you're happy.
Hello everyone. Let me just give a brief summary of what my paper is about. It's just simply arguing that the current laws that we have municipally are not sufficient to meet the objective of sustainable development globally. Yes, I mean, it stands to reason that you can't meet the objective of sustainable development if you do not have the right measures municipally, because it's the states that make up the globe. Okay, now this concept of sustainable development, you know, in the morning session, somebody actually did a differentiation between foundational principles and operational principles, putting sustainable development under foundational principles and then precautionary polluter pays principles under operational principles. Well, I think that's an apt classification because in the 1970s, a lot of initiatives emerged, you know, with a view to protecting the global environment. And one of these kind of initiatives was the emergence of principles of international environmental law. One of such principles was the precautionary principle, is the precautionary principle. In summary, that principle is a call to protect the environment in a precautionary way, in a preservationist manner, in the light of scientific uncertainty. Now, looking at sustainable development is actually a principle based on a principle, if you allow me to put it that way, in the sense that it's intergenerational in its content. That concept, sustainable development itself, is a tired one because a lot of people talk about sustainable development in all the fields. You hear sustainable development. Sometimes you tend to think that the term itself is being abused. Okay, but let's take the pains to re-examine what this concept of sustainable development actually is. The concept actually gained international recognition in 1987 and was defined, well, most popular, or one of the most popular definitions of sustainable development is the definition given in the Brundtland Report of 1987, Our Common Future, which defines sustainable development as development that meets the needs of the present without compromising the ability of future generations to meet their own needs. Now, if you look at the last part of the definition, compromising the ability of future generations to meet their own needs, this definition itself has an intragenerational content and an intergenerational content. Now, I don't think that's too much for us to understand. Intergenerational simply means in the same generation, and intergenerational means from generation to generation, between generations. Now, the objective of sustainable development is actually the later part of the definition, which is preserving the environment for future generations. Now, this is what sustainable development seeks to achieve. It seeks to adapt material progress to the constraints of natural equilibrium. What that simply means is it seeks to meet a compromise between the right to develop and the need for environmental protection. Now, it's a very holistic concept. It's something that's very profound and shouldn't be overlooked the way it is right now. This is the rationale for sustainable development. It seeks to change this divergent relationship between man and the environment to a convergent one through laws. Let's pause here a while and re-examine law as an instrument of social change. Yes, there's actually a symbiotic relationship between law and social change. The society affects law, and law affects the society as well. But it's not as simple as that when we're talking about law impacting society. But it still doesn't change the fact that law is an instrument of social change if the, what do you call them now? If the constraints that are involved in preventing law from impacting society are tackled. But now we wouldn't need this presentation if we had apt laws, if we had adequate laws for preserving the environment. The key word there is preservation, because of the objective of sustainable development, because that's what it's about actually. Now, we wouldn't need this preservation if we had apt laws to preserve the environment, that we're preserving the environment, right? Now, environmental laws generally are underpinned by several theoretical and philosophical theories. There are actually 4 broad theories. The first one is the animal liberationism. The second one is biocentrism. The third one is ecocentrism. And then we have anthropocentrism. Under anthropocentrism, we have the strict and we have the weak or enlightened anthropocentrism. Generally, animal liberationists say that cruelty to animals shouldn't be seen as immoral because it would amount to cruelty to human beings, but it should be seen as immoral because animals themselves feel pain. In other words, they're sentient. Now, biocentrists on their own say that the moral duty we owe to animals should be extended to all life forms. Now, I want to imagine that we would be agreed on the fact that all life forms would include plants as well. So biocentrists would include animals and plants, that's flora and fauna. Ecocentrists are more holistic in their view, in their perspective. They say our moral duty is to all life forms as well as non-life forms. In other words, we owe a moral duty to protect living and non-living nature. Of course, non-living nature includes the mountains, the air, the water, and so on and so forth. Now, the anthropocentrists on their own, which I'm sure most of us already know, deal with, we must have heard that this morning, deal with the human concerns, basically. They believe that everything is centered around man's needs. Now, the strict anthropocentrists believe that man alone has intrinsic value. Everything has to do, or everything has to point towards the satisfaction of man's present needs. The weak anthropocentrists, on the other hand, still elevate man, still think that things should revolve around man, but are very conscious of the fact that there's a need for harmony between man and the environment. So they stop sometimes to question themselves on certain ecological irrational commitments. They can actually do that. They can actually think, for instance, a weak anthropocentrist might decide not to destroy nature for its aesthetic value, right? Good. So that's the difference between strict anthropocentrists and weak anthropocentrists. I repeat, the strict anthropocentrist is very particular about meeting his present needs, and a weak anthropocentrist still elevates man, but stops to think or is very concerned also about the harmony between the human and the environment. Now, for clarity, I'll just do a broad classification of these philosophical theories. I'd like to put the animal liberationists, the biocentrists, and the ecocentrists under the ecocentrism group. Why? Because the animal liberationists talk about the animals, biocentrists include the animals when they talk about all life forms, and the ecocentrists talk about the animals, the all life forms, and man. But now the difference between ecocentrism and anthropocentrism, on the other hand, is that ecocentrism includes man as an equal member of the ecological community, But anthropocentrism puts man in an exalted position in the ecological community. So that's why there are two broad headings, ecocentrism and anthropocentrism. Now, we want to look at what kind of laws do we have on ground now? Do we have ecocentric laws or we have anthropocentric laws? Internationally, the kind of laws we have portend well, actually, for the objective of sustainable development. They have good preservationist provisions. Here you have the World Charter for Nature, you have the Earth Charter, you have the Rio Declaration, and you even have the proposed Universal Declaration on the Rights of Mother Nature of 2010. Yes, I agree with Anthony Benjamin when he said that the Stockholm Declaration and the Rio Declaration, even if they are soft law instruments, have actually had great influence on municipal laws. But the influence is still negligible, in my opinion, considering the kind of provisions that these instruments have. Why? Because municipally, the laws are still anthropocentric, strictly anthropocentric. In other words, they are still based on satisfying man's immediate needs. If you look at the other side of the comparison, where I talked about municipal laws, I said 70% of the constitutions worldwide provide for the right to a clean environment. Whether they're providing for the right to a clean environment through the fundamental objectives and directive principles of state policy, or they're providing for this right as express fundamental rights, they are still grouped under the 70%. Now, I group them as such because even if I have a right to a clean environment, and I come to the court saying that this right to the this right that I have to the clean environment has been infringed, and the court wants to rectify that wrong, all the court is going to do is going to affect me and not nature. In other words, nature is hardly a beneficiary of that rectification. Nature still remains at the point of an object and not a subject, so it is hardly preserved. What that means is, even if I have a right to a clean environment and the court seeks to rectify that wrong, it is reactive and not preservationist, which is the objective of sustainable development. Now, of course, it's taken for granted that if the primary law of the land has a particular provision, the same spirit will flow onto the secondary laws of that land. So you have several environmental pollution laws, several environmental protection laws. Some of them are criminal laws, some of them are civil laws. So even if they're criminal laws and they have fines, some fines are laughable, some fines are not. You have civil laws, compensations can be adequate, some of them might not be. But whatever the case is, doesn't matter how strong the laws are, it doesn't matter if they're properly enforced laws, they are also reactive, not preservationist. Now, we have a little bit of hope, however, with countries like Ecuador, Belgium, Spain, Switzerland, Germany, and Austria. How? Ecuador, for example, has a preservationist ethic in its law now. In its 2008 constitution, you discover that Articles 71 and 72 provide a right for nature to come to court, actually, to challenge its rights to existence. Now, that is preservationist, that is forward-looking, and that's less myopic than strict anthropocentric laws that we have already. In 2011, for example, there was already a case based on Article 71 of the Constitution against the provincial government of Loja. So it shows that the law is actually potent. Now, for Belgium, Spain, and the rest of them, they are following in the same line, but not as profound as Ecuador is, because much of what they are doing is to propose for animal rights, although Switzerland differs a bit because it talks about plants as well, it includes plants. Now let's go back to our classification, the broad classification, ecocentrism and anthropocentrism. Which of them is preferred? Certainly not strict anthropocentrism, based on what we just said, based on the fact that it is reactive and it meets only the immediate needs of man and blocks out the preservationist side, which is the basis of sustainable development actually, does it then mean that we'll have a swing of a pendulum to ecocentrism? Now, the question is, we can't do a swing because, as I mentioned earlier, let's revisit the definition of sustainable development which I gave earlier. The objective itself is anthropocentric. Why? Because it's talking about meeting the needs of future generations. It's human beings that are in future generations anyway. So we cannot do away with anthropocentrism completely. At the same time, we cannot use anthropocentrism as the method because it is myopic in its perspective, in its operations. Because at the beginning I also mentioned that the sustainable development principle is based on the precautionary principle. So it's going to remain an ideal unless we use precautionary measures to try to achieve that objective. Now, what's the method we're proposing? The method I'm proposing to achieve the objective, the anthropocentric objective of sustainable development is this ecocentric objective. How do we do that? We bestride the two objectives, we bestride the two ethics, ecocentrism and anthropocentrism, and call it, if you like, eco-anthropocentrism, whatever you want to call it. But the whole idea is ultimately, states, municipalities must come to a point where they will follow the pace set by Ecuador, Spain, Austria, Switzerland, Belgium, and so on, in the terms of having preservationist provisions, especially in their primary laws, those of them that have written constitutions. So let me now conclude with Aldo Leopold, when he realized the paradox of sustainable development. He said, conservation is a state of harmony between man and land. And Grumbine corroborated by saying, if ecosystem management is to take hold and flourish, the relationship between the new goal of preserving ecological integrity and the old standard of providing goods and services for humans must be reconciled. This depends on utilitarians, which is anthropocentric, recognizing the folly of relentless consumption, and environmentalists, ecocentrists, accepting the reality of society's continued growth. What is advocated now is sustainable development in an environmentally and socially responsible manner through discussion, redesign, and active negotiation with potentially affected communities. Now, this is a very apt Kenyan proverb that says, treat the earth well. It was not given to you by your parents. It was lent to you by your children. Thank you very much.
Thank you very much for that, Ngozi. That was very interesting presentation, picking up on themes that we've been hearing today from the plenary sessions to some of the sessions that we had here this morning. Our next presentation is by Nicola Ween from the University of Otago, New Zealand, and her presentation is on fishing-related mortality, the precautionary principle and the law in New Zealand.
Okay, now the first thing I have to do is find my presentation. So now then, I know I've been shown how to do this. Push that button down there. No?
We might
Push that
need
button
some
down there. Okay, so it's because I'm not at the end of this one. That's not what I should have done. Push that button down there. It's oh, there you go. All right. Thank you. Okay, I'd like to start by just reminding ourselves of one of the things that Scott Fulton said this morning. He talked about the biggest challenge facing us really being about actualising our aspirations. So for me that means how we take what it is we're trying to do and make it become some sort of reality on the ground. So what I'm looking at, and what I've been looking at for about 5 years, and I'll explain to you why, is about precaution and the precautionary principle and how it's been adopted by New Zealand's fisheries legislation, which it has been, and I'll show you how, but really how it's been interpreted and implemented in the few judicial decisions that we have. Now the purpose of it is, I guess, is to take something like the idea of precaution or the precautionary principle and say, well, how is this actually working out on the ground in a real life situation, which is the situation of fishing related mortality. So it is quite a simple and small thing that I'm looking at. I have 4 cases, 3 of them are New Zealand High Court cases, and 1 of them is a New Zealand Court of Appeal case, which is a leading case. So it is a quite small and particular issue. However, I think it has quite major ramifications, and I'll try again to explain to you what those are. So in order to do that, I'd like to show you 2 of the things that I'm most concerned about. Firstly, here is New Zealand sea lion, Photocarpus hookeri, sometimes known as the Hooker's sea lion, but today we call it New Zealand sea lion. The 2 names afterwards are the 2 Māori names for New Zealand sea lion. The male and then the female is the kaki. So that's what they look like, and I'll explain to you the relevance of them. However, one of the things that you might like to know about New Zealand sea lion, or might not like to know about New Zealand sea lion, is that it suffered a 40% decline in its population over basically the last 10 years. So New Zealand sea lion is in terrible trouble, and it's just recently been declared a nationally critical species in New Zealand. Okay, so that's one of the reasons why I'm up here, and here is the next reason why I'm up here. This is Hector's, or Hector's dolphin. It has a subspecies, Maui's dolphin, or Maui dolphin. I don't have a Māori name for this one because it has a range of Māori names, so it just took up a lot of room on the slide, so my apologies for that. To your right is a Hector's dolphin as we would like to see it, thanks, playing around in the sea. And to your left are 2 images of, unfortunately, how these days we more often see Hector's dolphins, which is entangled in some form of fishing gear. In the top, it's a bit harder to see, but it's been caught in a fishing net, whereas here you can clearly see the fishing line wrapped around the body of the mammal. Now, of course, both of these animals are mammals, so if you hold them down under the water, they're going to drown. All right? Dolphins only swim forwards, so once they swim into a fishing net, they're not coming back out again. That's it, they're going to drown. Okay, so these 2 species are both New Zealand endemic species. New Zealand has an incredibly high rate of endemism. Around 90% of our species are endemic species. And that's very unusual. The reason for that is that if you've ever found New Zealand on a map, we're quite geographically isolated. So many of our species have, in fact, evolved in that geographical isolation. Originally we had no land-based mammals, for example. There's birds and reptiles, yes, but no land-based mammals. So we're quite geographically isolated, which means that we have an unusually high number of endemic species. Okay, now the issue for that is the biodiversity issue, isn't it? New Zealand has a special responsibility, really, to preserve its endemism in terms of global biodiversity. Now, why does biodiversity matter? Well, again, I'll draw on something that was said this morning, that one of the things that's come out of Rio Plus 20, and when we talk about ecosystems, the thing that has been added to in the Rio Plus 20 when it comes to ecosystems is talking about resilience. Well, ecosystem resilience, what's probably the most important factor in ecosystem resilience is biodiversity. Okay, so biodiversity is incredibly important to preserve, and this is why I'm determined to spend a considerable amount of time trying to do what I can to protect these 2 species. Now, these 2 species are imperiled by fishing activities. Okay, so as a lawyer, what can I do about that? Well, one thing I can do about that is I don't eat arrow squid, and I don't eat New Zealand hoki. Okay, because those are the 2 target species that cause most of the fishing-related mortality for the species with whom I am concerned, or with which I am concerned. Obviously, the other thing I can do as a lawyer is turn around and look at the law and try to find out what it is about the law that means that this situation perpetuates. So that is indeed what I have been doing. Okay, so just a little bit of background here first on fishing and fishing-related mortality in New Zealand. We don't seem to call it bycatch in New Zealand. We call it fishing-related mortality. Bycatch is, that generally in New Zealand when we're talking about bycatch, we're talking about other fish that get caught in fishing rather than mammals. Okay, so fishing-related mortality is what I'm talking about. Now, the first bullet point is intended to give you some idea of how important fishing is to New Zealand. New Zealand's a pretty small place when it comes down to it, but you know we're a series of islands right in the middle of the sea. And all around us, we've got an extended EEZ. We've got a massive amount of fisheries waters for which we are responsible. And fishing, commercial fishing, has been consistently within the top 5 sectors contributing to the New Zealand economy. So, you know, up there you'd obviously put agriculture with New Zealand, but fishing is right up there as well. It is very important, commercial fishing as an economic activity in New Zealand. Add to that, 20 to 30% of the New Zealand population enjoys recreational fishing. So we've got a lot of people out there fishing. Okay, and they don't always do it necessarily by what you might describe as the most benign methods. Trawling, set netting and long lining are all very prevalent fishing methods in New Zealand fisheries waters. Okay, and I'm assuming that people know what trawling, set netting and long lining are. But if anyone shakes their head, I'll give you a brief explanation. No? Okay, well trawling is you trawl a big net behind your fishing boat and you catch whatever you get in your net, basically, in a very basic explanation. It's a great big trawl net and you just basically get everything. Some of them are bottom trawlers and they reach the seabed, but it depends what it is they're after. The ones I'm concerned work higher, but mainly we're trawling for squid. Set netting is where you put a net, you fix one end, usually on land, but it can be a little bit into the water, and then you take the other end and you fix it out in the water, and you set your net, in other words you leave it there, and you walk off, you leave your net, and you catch what swims through it. So you don't stay there and watch your net or remove it when you finish your fishing effort, you just indeed set your net and go away and leave it. It's often described as a very lazy way of fishing. Long lining is a very long line dragged behind your fishing vessel with baited points all the way along it. And long lining is a particular problem for seabirds because you're dragging a long line behind your fishing vessel with hooks all the way along it that then will drop down into the water. Before they drop down into the water, all the bait at those stations is floating at the surface, and indeed seabirds will go for that and then they swallow the hook and then they're pulled underwater and subsequently drowned. Long lining is a common method used for tuna. Set netting is more often a recreational method, and trawling is usually a commercial, a very non-discriminating commercial method. Okay, now the problem is, of course, that all that busy out there fishing is going to have consequences, and indeed the consequences are something like this. And again, I've just given you some sort of snapshot, 736 New Zealand sea lions. This is in one fishery, okay? Drowned in the Auckland Island squid fishery between 1997 and 2007, resulting in a 40% population decline in that species since 1995. Okay, now why am I only really concentrating on the Auckland Island squid fishery? Because that's really the only place that there are sea lions left. Okay, New Zealand sea lion used to live all around the coast of New Zealand, from the tip of the northernmost tip to the southernmost tip. They have now been basically pushed all the way down the coast to the sub-Antarctic islands, off the bottom of New Zealand, where they have 3 breeding colonies left, of which the biggest one is the Auckland Island one. Now, unfortunately, that breeding colony in the Auckland Island is there, the Auckland Islands is there because there is an arrow squid breeding ground there. Okay, now that is what the sea lions are there for, and of course that is what the trawlers come in for also. Fishing is also the main threat to hectares and Maui dolphins. This is a species that, even with the most recent conservation measures, is still in continuing decline. And we've now got to the stage in New Zealand, well, there were thought to be about 77,000 hectares dolphins in the 1970s, but of course then we've got nylon fishing nets and all the rest of it. And now we're down to the stage where we've got around between 5,000 and 7,000 hectares dolphins left, of which the subspecies Maui dolphins, we now reckon that we've got 55 Maui dolphins over the age of 1 remain, and that's over the breeding, into their breeding age. So 55 is not really much of a population to go on, and you would think you'd be doing something pretty urgently to try to alleviate that situation. And indeed we have done some things. Thank goodness. For the sea lions, we have installed a marine reserve that goes out to 12 nautical miles offshore around the Auckland Islands. Now, if the sea lions, bless their little cotton socks, know that they're supposed to stay within the marine reserve, then they're absolutely protected. But of course, once they go beyond the 12 nautical miles, they go beyond the protection that the marine reserve provides. Okay, and there's quite a lot of research to show that foraging sea lions indeed go well beyond the 12 nautical miles. In fact, the New Zealand sea lion has the longest of all the sea lions in the world, is the one that spends the longest time underwater. Okay, now the time that a sea lion spends underwater represents how long it has to spend underwater in order to find food. So New Zealand sea lions are spending a long time underwater trying to find food. They go well outside the 12 nautical miles. So beyond the 12 nautical miles until indeed this year, we used a FRIML, what we call a FRIML, fishing related mortality limit, set by the fisheries minister. Okay, now the FRIML is a limit on how many sea lions can be taken per season, per squid fishing season. Okay, and the way that it's worked out, or has been worked out in New Zealand, is really quite, well, it's too mathematical for me. But anyway, the way they work it out is they say, they try to estimate, and I'll explain to you what the methods that they are that they've used to try to estimate. They try to estimate how many deaths the sea lion population can sustain. And if they say, well, we reckon that's about 120, which they don't, but if they did say it was about 120, then they would say, okay, so on one run of a squid fishing vessel with its trawl nets out, we would catch 1.2 sea lions. Okay, that's an average. So therefore we will allow the squid fishing vessels to do so many tows, at 1.2 sea lions per tow, and when they've done that number of tows, they have to stop fishing because they've reached their FRIML. Yeah, so it's not necessarily based on counting the sea lions, it's based on this sort of calculation of an average of how many sea lions are taken per run or per tow of the squid fishing vessel. This year the FRIML was completely done away with, we don't have one anymore, and the reason for that is that we've put all our eggs in the sled basket. Now a sled is a sea lion exclusion device. It's a little hatch that the sea lion is supposed to know to escape out of the trawl net via. And indeed there are ways of guiding the sea lion up to the sled so that it escapes from the net. The problem is that we're not really sure how many sea lions actually escape through the sled alive or uninjured. It seems that a large number of them indeed receive injuries in escaping the net that would mean that they don't survive anyway. But anyway, we've decided that we'll lift the FRIML and rely on sleds. I say that a little casually because that's kind of how it feels. The dolphins, largely we've used bans on set nets, again installed by the fisheries minister, and we've simply said in these areas where we think there are dolphins, you shouldn't use set nets. Now think is pretty loosely defined. This year indeed a Maui dolphin was caught outside the protected area, and all the conservationists turned around and said, how can this happen? And the minister said, well, we didn't know that there were Maui dolphins there. Indeed, there aren't any Maui dolphins there. And we said, well, it's quite hard actually to believe that when one was just caught in a fishing net right there. But anyway, so my extrapolation from all of that, thank you, is that the progress that we have made has been very slow and difficult in trying to protect these species. and they're still both in severe decline despite the measures that we have, right? So you ask yourself why that might be. Now, all these measures are being installed by the, or such measures as there are, as I've set up on the slide, are being installed by the Fisheries Minister under the Fisheries Act. The Minister of Conservation has largely withdrawn from the process, and that's a real reason for political dominance, really, between the Fisheries and Conservation departments. So you turn around and you look at the Fisheries Act, which the Fisheries Minister is acting under, and you start looking for problems with the Act. Okay, now I've got a couple of problems up there. The purpose of the Act is a balance between utilisation and conservation, and I would argue that when you're dealing with an imperiled species, you want to just go all out for conservation. But anyway, and also Section 15, which is the actual section that the Minister uses, allows the Minister to take only necessary measures to protect those species rather than reasonable or something like that. Necessary is a pretty high standard, so you pretty much have to show that without the measure that the species is going to go, okay? But to me, this is really the biggest problem. This is Section 10, and this is what I would describe as the precautionary section in the New Zealand legislation. Now, I'm assuming you can all read, but I'll still read it out to you. Basically what it does is it says to the Minister that when the Minister is installing measures, the Minister shall take into account the following principles. And then it lists these principles, so it's a duty to take these things into account. Okay, and then it lists these 4 principles. A, decisions should be based on the best available information, the BI. B, decision makers should consider any uncertainty in the information that they've got. C, if there is uncertainty there, the decision maker should be cautious. And D, this is the real precautionary statement. The absence of or uncertainty in any information should not be used as a reason for postponing or failing to take any measure to achieve the purpose of the Act. Okay, now that more closely resembles what most people, I think, would regard as a precautionary statement. In the case of uncertainty, or scientific uncertainty, should not stop us taking measures for conservation or environmental measures. Okay, now the reason for the rule, of course, is to end that paralysis in decision making that stops you conserving the environment where there is scientific uncertainty. It enables you to move on past that uncertainty and conserve or take those environmental steps that you need to take. Right? That's the point, the raison d'etre of the precautionary principle, is it lets you get out of that situation of paralysis. Okay, so in New Zealand we have 4 cases. You'll note that they all involve a fishing organisation against the Minister of Fisheries. They're not brought by environmental organisations protecting their interests, they're brought by fisheries companies, industry representatives protecting their interests. Okay, so first of all we had a challenge to the first set net bans that were introduced to protect the Maui dolphins on the west coast of New Zealand's North Island. Now the challenge here was based around a failure on the part of the Minister to base his decision on the best available information. The flaw in the information was that the Minister's information was out of date as to the economic impact of the set net ban on local commercial fishers. Indeed the industry won, and the judge put a lot of emphasis on the importance of the so-called duty to base decisions on the best available information. Didn't really go down through the rest of Section 10 into paragraphs B, C and D, most crucially, just really stopped at paragraph A and said, look, this is a duty to base decisions on best available information. Indeed it isn't. It is a duty to consider that you should base decisions on the best available information, but it's not actually a duty to base decisions on the best available information. Section 10D, the precautionary principle, not even mentioned at all. No one said, hang on, you might have uncertainty, these dolphins are still important. Squid fishery, the next case, obviously this one's about sea lions, and what happened here was that the industry argued that the Minister shouldn't have closed down the fishery when the fishing-related mortality limit for the sea lions was reached because the limit was too low. Okay, and they said that the fishing-related mortality limit should have been higher, and the reason for that is that there should have been an inbuilt discount into the minister's calculations for those vessels that were using sleds. So if 20% of your vessels are using sleds, then that should enable you to have a 20% higher FRIML. Okay, the minister refused to have a discount because he said, I don't know very much about sleds. Indeed, he said there was no information about sleds. And the industry was able to point to an industry-sponsored publication about sleds. Now, what that said was that 90% of sea lions can get out using sleds, however, 40% of them are likely to suffer life-threatening injuries. So actually the research wasn't very good about sleds, but there was research out there. And the minister had said there was none, therefore he had based his decision on the best available information, because there was information available and he didn't know there was any. All right, so you can forget paragraph 10D. I'm going to end the case at paragraph 10A on the by. Right, and we're not going to say, oh look, there's an information deficit, never mind, we'll protect the sea lions. That's not what we say. This is the leading case, a hideous case it is as well. This was a challenge to the 2003-2004 FRIML of 62 sea lions. It's a little complicated because the minister had previously used what's called the Wade or PBR rule to try to ascertain how many sea lion deaths the sea lion population can sustain. Now the Wade model is the model that was probably used here. A potential biological removals model, whereas in New Zealand we've developed our own model specifically for sea lions called the Breen-Kem model. Now stupidly, the Ministry of Fisheries went into the case accepting that the Breen-Kem model was the best available information. They didn't contend that issue. Okay. Now the minister came out with a decision when setting the FRIML that looked an awful lot like he had used the Wade rule, the old rule, and not the Breen-Kem model, not the new rule. Okay, now the reason for that was that applied to the sea lion situation, the Wade rule said that the population can sustain around 65 deaths. And look, he set his number at 62. 62 is quite a lot like 65. The Breen-Kem model had said, oh, the sea lion population can sustain unlimited deaths. Indeed, 627 seems like quite a nice number. Okay, so it was returning hugely different results to what the Wade model, the model that the minister had hitherto always used, was returning. Okay, so you think to yourself, well, if you were the minister in that situation, you had this brand new spanking model and this old one, and the new one was returning results that were vastly different, would it not be a good idea to be a little bit cautious and just stay with Wade for another year until you work out how good your Breen-Kem model is? Wouldn't that be a good idea? Well, unfortunately, as I said, the ministry had already said that the Breen-Kem was the buy, so no. The minister has to base his decisions on the best available information. That's what the Court of Appeal said, and the decision, again, was overruled. Now, I would argue that the High Court below was right, that it was open to the minister to take cognizance of the fact that he was dealing with a new and uncertain model, and therefore to use paragraph 10D and make a decision in favour of the sea lions. And the last case here is, again, a Hector's dolphin one. We've gone back to the beginning. And we've extended the set net bans now for these dolphins. And again, we have a challenge, and one of the challenges in the case was based on the reliability of one sighting of one dolphin, and that was used to completely adjust the boundaries for where the set net bans were to go out to. But Justice Mallon said this thing in the middle here. She said, in the usual course, decisions are to be based on the best available information. Now, under Section 10, the Minister is required to consider this. Now, that means, according to Justice Mallon, that the Minister must know what information is available and at what cost and in what time frame. And then if he or she decides not to base the decision on the best available information, he or she is going to have a reason. Well, that kind of makes sense, except I reckon it puts quite a heavy burden on the minister to know all the information that there is out there, published and not published, that could be part of the relevant information base. Because unless the minister knows that, the law says they can't proceed on the buy. Okay, so in all cases, I would argue, in all those 4 cases, information deficiencies under paragraph A, the best available information provision, have resulted in precautionary decisions, precautionary measures being set aside. There's been a top-heavy reliance. All the emphasis has gone on paragraph A. And to me, that fits rather well with some writing by Warwick Gullett, who's an Australian who writes about the precautionary principle in a fantastic way, where he said that best available information statements, like we have in paragraph A, can indeed work against the precautionary principle in the sense that we actually know it and expect it to work. What we're expecting the precautionary principle to give us is that in a case of information deficit, we're going to err on the side of the environment. Well, when you mix a best available information statement with a precautionary statement in the way that we have done in New Zealand, without prioritising the precautionary statement over the buy, the likely effect is going to be that you defeat the effect of precaution and all the emphasis goes on the buy. Okay, so I argue that that's contrary to the whole existence, thank you, of the precautionary principle and indeed to the Convention on Biological Diversity, the Rio Declaration and the FAO Code on Responsible Fisheries, which is the relevant international law. And basically we've got it wrong in New Zealand. Okay, I told you I could talk all week about dolphins. Okay.
We have plenty of time for questions.
Bet there aren't any.
Well, I have one for Gozi. I found your talk incredibly interesting because animal law is another one of my special interests, and I still haven't yet figured out how to meld that with my environmental law interests because in some cases there's a huge conflict. With the approach that you took, is there any way of giving, of saying what weight is given to each of these elements? Because if you're looking at something that's ecocentric or anthropocentric, you're still looking at components that might not actually match up. So if you're trying to bring them together, are they each treated equally or some different weightings depending on the circumstances?
Okay, thank you. That's actually one of the reasons why I proposed a broad classification of both of them for ecocentric on one side and anthropocentric on one side. I did that because it is easier to weigh the value of other living creatures with man as against weighing the value of one non-human creature with another non-human creature. In other words, for example, it's more difficult to compare the value of a butterfly with a turtle to the comparison between a human being and a turtle. I don't know if it's making sense. Yes, so that's why the broad classification is there. So as far as I'm concerned, under the ecocentric classification, you have all of them together, yes.
I have a question.
Sorry, please.
Yeah.
Do you know where your name?
I'm Alison Reeser from the University of Hawaii.
Thank you.
And it's interesting, Nicola's conclusion, because the best available scientific information standard, from what I understand, the way we look at it, is that it was a very early formulation of the precautionary principle. It was, and it may be that it's the way that it's worded, where the emphasis is on best, which implies it has to be really good scientific information, the most up-to-date, the most recent. And I think the original intent was to not wait until you have better information, but whatever is available, you make your decision. And if you have no information, then you decide, you make some kind of decision so that you can go forward with measures. And it just seems really contrary to that whole idea that this has happened in New Zealand. And I'm wondering if there's some way that the Department of Conservation can be reactivated, like sue it for withdrawing its required role to consult with the Ministry of Fisheries. I would imagine the Fisheries Act requires the minister to consult with the Department of Conservation, not so much?
Legislatively, there's an uneven relationship in that the Minister of Fisheries has to consult with the Minister of Conservation.
Yeah.
But for the Minister of Conservation to act, the concurrence or consent of the Minister of Fisheries is required, which I think is why conservation has backed out, because they can't act without the Ministry of Fisheries say so. So anything they do is potentially a complete waste of time and money, and they may as well just let fisheries do it.
Do you think that this is an outcome or result of the devolution of fisheries to the quota-owning companies?
Yes. Yeah. I think the main problem in New Zealand is the power of the fishing industry, and I think the power of the fishing industry comes from the quota management system. The ownership of quota gives commercial fishers a much stronger interest in protecting their interest. And in New Zealand, the quota are held by a, you could count on your fingers the number of families, companies that hold quota in New Zealand fisheries. Many of them aren't New Zealanders either. Not that's particularly relevant, but they, for a small group, they hold a lot of power. And I would argue, and there's a woman called Kath Wallace from Victoria University of Wellington who writes about this from a more political standpoint, that a lot of the problem is the political clout of the fishing industry. So my efforts at looking at the law are really about trying to shut that down.
One final observation, and I think that the efforts to reduce the bycatch or the incidental mortality of seabirds in the longline fisheries has been much more successful. And what's different about that industry or that fishing sector, that they've been willing, or is it that BirdLife International and the bird people have been much more effective in, because the situation is very dire for certain populations or certain species of albatrosses. So I'm just wondering why New Zealand fisheries are so solicitous of seabirds, but they don't care about the disappearance of the dolphins and the other marine mammals.
I would argue that it hasn't been so great for the seabirds, actually, either. We've had a great deal of problem moving forward with the seabirds.
Okay.
We haven't even got a meaningful plan on seabirds. What we have is a series of sort of regulations. So we have nighttime fishing, Tory lines, these sorts of things. But most of the seabird type fisheries are well away from the mainland. So while we may have those regulations, on the few occasions we have like 55 fisheries observers for our whole fishery. Okay, so the few times when we actually go out and monitor the seabirds, it doesn't look that great either. And we really have no idea what is happening with seabirds, to be honest, when you read the information. They were going to have a fishing-related mortality limit for seabirds, but the only way they could think of doing it was all species, because they didn't know what numbers of which species were being taken. They had no idea at all, so they thought, well, if they just put a cap on all species, maybe that would work. But the industry balked at that. And so then they said, well, we'll go species by species, because obviously you don't think that's fair. And now, once again, we've got ourselves into the situation where we're not moving forward because we can't do it species by species. So I actually would argue that it's not that great for seabirds either, and that there are many endemic seabirds that will be rendered extinct. I mean, Mounties dolphin, we're looking at losing this generation, really. And I would say that it's the same for many, many endemic seabirds, actually. It's a terrible story, the fishing-related mortality story in New Zealand. And I agree with you what you said about the buy. I can see that that was sort of maybe a compromise situation. Look, you know, you can't spend your whole time trying to get all the information. You've got to go on what information you've got and the best information that you have, you know. You'll never get anywhere unless you actually draw a line in the sand and say, at this point, this is the information we have and we need to act. And I don't think it's necessarily wrong to have it in the legislation. The problem is that we never seem to get down to paragraph D, you know? And the industry just sees the buy thing and goes, well, you haven't got the buy. And they just totally focused on paragraph A. So somehow that prioritising needs to be adjusted, and someone needs to give the message that, you know, we're not going to have all the information, and meanwhile...
Well, they focus on paragraph A because they're the plaintiff.
Yeah.
But if you had, you know, the Royal Society, the plaintiff, you could focus on section 10D.
On D, yeah. Yeah, but
So,
we don't have those kinds of... We're not so well...
You don't have the resources for lawsuits.
Not really, no. It's up to the environmental organisations to... Yeah, we have no, you know, a proper advocate for environmental issues. Yes.
Yeah, the name is Brooke Sacco from the University of Hull Law School in the UK. My comment/question is to Ngozi. I found the presentation interesting and almost personal to a point, because I almost had to write 2 PhDs to satisfy one of my supervisors who is eccentric. All right, so I mean, I do understand, you know, the agros involved with that grouping. The question I have though is when you make this suggestion of, you know, whatever name you call it, eco-anthropocentrism, I mean, are you looking at this from a rethink on theoretical models, or are you looking at it from like a practical perspective, or both? Because the problem I see from, you know, practical perspective is obviously countries, people at different levels of development have different concerns. And if you use oil spills, for instance, you'll see that in the US, when there was the BP oil spill, the pictures that were shown on world media, for instance, were pictures of birds. And, you know, so much emphasis on destruction of biodiversity. On the other hand, if you look at Nigeria, where these things happen on a daily basis, no one cares about birds, animals that get killed or harmed in these things, because for the people there, it's more about human survival. And, you know, these differences, I'm sure in Australia and, you know, other places, you know, there are these differences. So, you know, my question really is, you know, at this point, are you talking about a reformulation or rethink, perhaps first on a theoretical level, and then, you know, how do you sort of see that playing out, you know, practically?
Yeah, eco-anthropocentrism, first of all, is actually advocating for a paradigm shift generally. I mean, in terms of the ethics that underlie environmental protection laws. Now, okay, narrowing it down to Nigeria, for instance, let me first of all mention that eco-anthropocentrism is not a new term as such. It's actually a renaming of weak anthropocentrism, which I tried to explain earlier. I'm renaming it because of the emphasis on the rights of nature. Now, I'm very confident about the fact that we can actually achieve that paradigm shift because of examples like Ecuador. Ecuador is not such a rich country, for instance, and the environmental problems in Ecuador are very similar to the environmental problems that Nigeria faces, for example. And the reason why I'm particular about the rights of nature, for example, is because that way, like I mentioned, we're going to move nature from an object status to a subject status. So we're not just going to be talking about how it affects man, we're not going to talk about how it affects me, how it affects the air I breathe, my health and all that. We're going to talk about how it affects preservation of nature, and not just restoration, but preventing those kind of occurrences in the future. I mean, the truth is, eco-anthropocentrism actually, if it's implemented properly, like the right of nature, which I mentioned, using the examples of Ecuador and so on, it's going to make nonsense of the distinction between instrumental value and intrinsic value. Yeah, it's going to be, because if nature is having a right to existing, if nature can come to court saying I have a right to existence, then at the same time, it's being preserved. Its intrinsic value is being preserved, and its instrumental value is being preserved. So what's the need for the distinction? So, I mean, if I'm answering your question correctly, it's a renaming of weak anthropocentrism, emphasizing the rights of nature. And yes, it is not just theory, but it's very, very, very implementable, considering the example of Ecuador, I mean, which has very similar problems to Nigeria.
Just had one for Nicola. I was really just interested to hear all these problems. Does New Zealand have a means of listing threatening processes under any biodiversity protection? Because I know Australia listed the longline fishing with albatrosses in our EEZ as a threatening process, and there's management plans. I don't know how successful they are because it's not my field, but we do have management plans for longline fishing in albatrosses.
We tend to list threatened species
rather than
and classify rather than the processes. We can make fisheries management plans and these sorts of things. And there are all sorts of measures we can make. The problem is actually getting the things to happen. You know, it's a political kind of problem just as much as anything else. Yeah, we tend to focus on classifying the species. We don't necessarily associate that with a process. I mean, one of the biggest arguments that we've had in the last 6 months, after years and years and years of this thing, is that the squid fisheries have again stood up and said, well, you can't show that the decline in the sea lion population is due to fishing activities. Well, you know, it's quite obvious to most of us that if you've got squid there and that's what the sea lions are using and you're fishing them out, and indeed you're catching sea lions, that there's, you know, a problem there. But they're challenging that, so, you know, the scientists have had to go back. And I mean, the best thing they can say is that the most likely hypothesis is that it's the fishing. Now, this isn't even counting, you know, the starvation of the sea lions or anything like that due to depletion of the food source. If you kill a sea lion mother that's pregnant, that's 2 sea lions plus the pup that she's left on shore. And we only ever count the one that's actually counted in the fishing net, because fishing-related mortality is animals that are killed directly through fishing, so we don't count the indirect effects anyway. But when after, you know, 30-something years of trying to manage this problem and facing this population decline, you have an industry that can legitimately turn around and say, well, you can't actually show that fishing is the problem, and you have a minister that goes, yeah, you can't actually say that fishing is the problem. You know, you start sort of bashing your head against the wall, honestly. So no, we don't normally attach the activity, and that might be something that we could do, is spend more time actually identifying problematic activities. I think they would mostly revolve around New Zealand's primary industries. Oh, yeah.